All right. Thank you, everyone, for joining us tonight. My name is Laura Dobbs. I'm an attorney with the Virginia Poverty Law Center. And today with me, I have Victoria Horrock, who's with the Legal Aid Justice Center. Um, and we're going to start by going over the current state of the tenant protections that are in place slash are about to expire, and then go over some of the new laws that are going into effect next month. And then we'll have some time for some Q&A discussion if you have any questions. So at this point, I'm going to turn it over to Victoria to go over a few things, and then we'll go back over to me to talk about some of the new laws.
So as Laura said, my name is Victoria Horrock. I'm an attorney at the Legal Aid Justice Center, and I represent tenants in landlord eviction and housing discrimination cases in the Richmond area. We've got a small group, so we are going to have a Q&A session at the end, but like if anyone has any questions or if Laura and Marty feel like there's anything that needs to get said, just jump on in. So I'll start with the three basic things about landlord tenant law, and this session is going to be mostly about the current protections that are COVID related, so not just general. They're at least the beginning of it, but the three things that everybody should remember always that are true with landlord tenant law. The first one is that a landlord cannot cut off your utilities or lock you out or in any way sort of kick you out of your apartment without going to court. A landlord has to go to court and get a court order in order to evict someone in Virginia and probably most states. So if they threaten to lock you out, if they threaten to turn off the utilities, that's not a threat. And if the landlord does that, you can file what's called a petition for relief for an unlawful exclusion. And I would also call legal aid, either the Virginia Poverty Law Center or Central Virginia Legal Aid, or we at the Legal Aid Justice Center can all assist tenants either with advice or representation in filing those kinds of cases. The other one is that you don't have to move just because your landlord sends you an eviction notice or files the case against you in court. You only have to move after the landlord gets a court judgment and after the appeal period, which is 10 days, has ended and the sheriff puts a notice on your door. So you don't have to move after the first notice, you don't have to move after the case is filed, and you don't even have to move the day of the court date if you lose. You only have to move after the landlord wins, gets a court order, and you get a notice from the sheriff that the eviction's going to happen. And that actually can't happen for 10 days after the court date. So I think sometimes people are afraid when they get the first notice that they have to leave by the date on the notice, but that's not actually the case. The notice will usually say your lease terminates as of a certain date for some reason. Sometimes it's not paying your rent. Sometimes it's because you have a pet you shouldn't have, something like that. But it'll say your lease terminates as of this date, like you have to be out. But you don't actually have to be out on that date. That after that date, your landlord can file the case in court and you never have to get out until there's a court order telling you to. And the sheriff will always give you notice before they come, and they have to give you at least 72 hours notice before they come. So those are always three things to remember. It's a stressful time, but your landlord can't just change the locks on you. There are also a number of eviction protections that are in place for tenants currently because of the COVID-19 pandemic. As we all know, COVID-19 presents, an unprecedented health risk, and being homeless really exacerbates that health risk because you can't shelter in your home. So there are extra protections to keep tenants housed during the pandemic. Unfortunately, for a lot of tenants, they're pretty much exclusively for tenants who are being evicted for not paying their rent. They don't generally protect anyone being evicted for some other reason. But the first one that we wanted to go over is the Centers for Disease Control and Prevention Eviction Moratorium. And this one is true anywhere in the country. It's not a Virginia-specific protection. In September, I think, the CDC announced this eviction moratorium. And basically what it does is it will stop the physical eviction of someone who's being evicted for not paying their rent through the end of this month, June 30th, 2020. But there are a couple catches to it, and there are some things the tenant has to do to be protected. It's not automatic. It only applies to tenants who are being evicted for not paying their rent. And only if the reason they're not paying their rent is because of a large loss of household income or high medical expenses. Those don't have to be due to COVID-19. If you just had high medical expenses in general, you still qualify for the protection. You also have to be likely to become homeless or have to double up with friends and family if you were evicted, which is basically everyone. If you don't have the money to move, like this protects you. And then tenants who make less than $99,000 a year or less than $198,000 a year, so really high cap, probably everyone on this call is well under that. So you have to be under those income limits. And then again, you have to be facing eviction for not paying your rent, not some other reason. And you have to be trying to get government assistance. And we'll get into what government assistance is available, but almost everybody in Virginia should be able to fulfill that part of the eligibility test pretty easily. The other things you have to do is you have to keep paying as much rent as you can. So if you're getting like half your wages, like if your hours got cut, you have to keep paying like as much rent as you can. But you don't have to pay all the money that you have. Like if you also have to buy food and medicine and things like that, you can keep paying for those things as well. And you have to apply for government assistance, and you should definitely document your efforts to do that. And the big one is that you have to sign a declaration. And the link is right here in the PowerPoint. Also, you can pretty much just Google CDC Eviction Declaration and it'll come up. The CDC has its own form. You just check a box. It's pretty simple. Any of the legal aids, we can also point you towards it. And it basically, the declaration is, you sign it and it basically says all those eligibility criteria that I just went over. It says those are true. So it affirms that you make under a certain amount of money and things like that. And you can give that to your landlord at any point in the eviction process and it should stop the eviction. So even if you've already been to court and a judge has already ordered the eviction, as long as the sheriff has not come to your door and locked you out, this can protect you. But I would say to do it as soon as possible. And also, I don't know what Laura and Marty are seeing, but I would call the sheriff when you do that. If you've already gone to court and there's a sheriff's notice out, call legal aid, call the sheriff, because you may have to file a document in court to stop the eviction. And there's a lot of confusion going on with those types of cases. So, give this to your landlord as soon as you can. Give it to a property manager, give it to the landlord. If you're going to court, give it to the landlord's attorney, any of those things, and give it to the sheriff. I would sign it and make as many copies as you can. But it will protect you. It won't protect you necessarily from getting an eviction judgment in court, but it will prevent the sheriff from coming again through the end of this month. And it doesn't relieve your obligation to pay your rent. Like the rent will be due after this month, regardless of that, but it will keep the sheriff from locking you out. The next thing is the rent relief program. And this is where we get to how to get the rent. So the CDC moratorium prevents you from being evicted, but that doesn't help you with the rental bill. If you have lost income over the last year, you may owe a pretty high amount of rent. Luckily, there's a huge pool of money here in Virginia for people to get to pay their rent. And it's called the Virginia Rent Relief Program, and it's administered by DHCD, the Department of Housing and Community Development. I always forget that acronym, but that's who's administering it. Anyone in Virginia can apply, and the eligibility is here on the slide. The first thing that you have to have is a lease in your name or other documents showing that there's a landlord-tenant relationship. So rent statements with your name, notices with your name on them, things like that. If all else fails, I've heard a couple of people who work there say you could have like an affidavit from the landlord saying there's a landlord-tenant relationship, something like that. But the best thing to have would be a lease with your name on it that is current. You also have to have experienced a loss of income or expenses during the pandemic. So I don't think you necessarily need to prove it was because of COVID, but this has to have happened since last March. And that's something like being laid off, even reduced hours. You don't have to have lost all your income. Your place of employment closed, you lost child support, you had to stay home because your children didn't have school or daycare, you couldn't find work, or you're high risk for illness, so you had to quit your job because of that, or had high medical or work or childcare related expenses. All those things would qualify you for rent relief. You also have to have a rent amount that's at or below 150% of the fair market rent, and have a household income at or below 80% of the area median income. And again, if you're unsure of those things, I think that we're going to have some numbers from rent relief that can probably help you figure it out. You could call one of the legal aids, and you can also just Google those terms, and usually based on your family size, you can figure out whether you're under those eligibility tiers. So how to apply? There are a couple ways to apply. You can apply online, and the website is right here. You can apply by phone. There's one statewide 703 area code number, except if you live in Chesterfield or Fairfax. Those both have local programs. So those do not do the statewide program, but everywhere else has the statewide program. And Chesterfield and Fairfax have the same money with the same eligibility. It's just a different organization who's administering the program. There's also a really useful link here on the slide where you can check the status of your application. That's something that often your landlord is going to want to know. It's also something that if you have to go to court, a judge loves to see, is that you're checking the status and it's moving along. And they also have a little eligibility kind of quiz on the website that you can take if you're not sure whether you qualify for rent relief. But most tenants who are behind on their rent right now qualify for rent relief that I talk to. So I think, I'm going to encourage anyone who owes a little bit of rent even to apply. And then landlords can apply on behalf of their tenants, and the websites are here, and an email is here. And we're going to get into some of the current protections that require landlords to do this, at least through the end of this month. But also any landlord who's willing to apply, I would definitely just encourage tenants to ask their landlords to do it, because it's faster for landlords, and it's often easier for landlords because they have to submit a lot of the information, such as tax forms, and it's easier for them to do that directly. So I encourage all the tenants who call us to write like a written letter to the landlord and save a copy, asking them to apply for rent relief and offering to cooperate with the process.
I should have put this on the slides, but rent relief can cover up to 15 months of rent currently, anything from, I believe, April 1st of 2020 to the present. They can also pay for 3 months of future rent, as long as you have a lease agreement saying that your lease extends out to that period. There's a few exceptions if you're receiving some sort of rental subsidy, such as a Section 8 voucher, or if you live in public housing. I think they want you to first go through the Public Housing Authority to do an income recertification to get your rent obligation lowered before they pay out money. But so they can forgive a lot of rent. Don't be shy about how much you're asking for. And even if you've already received some money to cover any rental arrearage, if you're still struggling, you can go back and ask to get any prospective rent. Likewise, you don't have to have been on behind rent previously in order to get any prospective rent covered by the rent relief program.
Yeah, and just to add to that, you can also apply multiple times, so that monthly cap, that 15-month cap, like you could have gotten, I've definitely talked to clients who got some rent relief like last fall, for example. You can go get it again. If you got like 4 months of rent paid last fall, apply again, and you're still going to be under the cap. So that brings us to the tenant protections that exist under Virginia state law currently. And to start, here are ones that were enacted in a state budget, and these are going to be enforced until the end of the state of emergency, which is likely to be the end of this month, June 30th. The easy thing right now is that the CDC moratorium and these state budget protections end at the same time. So for the rest of this month, this is in place. Before your landlord can evict you for not paying your rent, and only evictions related to rent, they have to give you a 14-day pay or quit notice. That's a notice that says how much rent you owe, and it says like if you don't pay by X date, you have to leave the apartment. Usually under Virginia law, that was 5 days. It's currently 14 days, and that exists under this law and a separate law. But they have to give you a 14-day notice to pay the rent owed. They have to give you information about the rent relief program. And then the landlord themselves has to apply for rent relief on your behalf within 14 days of sending you that notice, unless you've already paid or they know that you applied on your own or you entered into a repayment plan with them. They are getting creative about how to get around this requirement. I've seen a lot of notices that basically say, have about 1 million words on them. They're pretty annoying to read. And they say, it's your pay or quit. And it says, this is how much you owe, pay it by this date. Otherwise, we're going to take you to court, essentially. And then it says, we want to apply for rent relief on your behalf, but you have to sign this thing and cooperate with us within a certain period of time. That's not required in the law for you to sign that thing. And if you come to legal aid, we're going to try to get creative about fighting the fact that they're sending these notices. But to smooth the way for you, if you get a notice that says, like, do these things to help us apply for rent relief on your behalf, I would definitely encourage you to do them. And feel free to call one of the legal aids to ask for advice about what those notices mean, because landlords are certainly trying to get around this obligation to apply for rent relief on people's behalf. And the result is some pretty confusing notices with this information in it right now. The other reason that they could just go ahead and file for eviction without applying for rent relief would be if you refuse to apply for rent relief, or if your application isn't approved by the agency within 45 days. I think it's actually right now 45 days after it was completed. But again, we're so close to the end of this protection. Essentially, like, they're not going to be able to file a case just because it hasn't been approved. The application, if the application is denied because you're not eligible, then the landlord can go ahead and file the case in court, or if the program has run out of money, but it's very unlikely that the program will run out of money before the state of emergency ends. And I should say, the program, even though that protection may end at the end of the month, the rent relief program will not end at the end of the month. So even though the obligation for your landlord to apply for rent relief may end at the end of June, that money is still there, and I still encourage tenants to apply and landlords to apply. The other protection that's in place currently is a 60-day continuance of an eviction case for non-payment of rent because of loss of income due to COVID-19. So if you lost income because of the pandemic and you're being sued for not paying your rent, at your first court date, that's the court date that you see on the summons you get from the court, you can go and ask for a 60-day continuance. And that doesn't take care of the case or like dismiss it or anything. It just gives you more time to pay the landlord, but it is a long time. I mean, that's 2 months where you can work on getting the rent together and apply for the rent relief through the rent relief program. And if the state of emergency extends until the end of this month, this protection will extend 90 days after that, which would be September 28th, 2021. I would say that it's just useful noting that this one is a little different than those other two protections, because for rent relief or the CDC moratorium, all you have to show is that you lost income kind of during this period of time. This one, you actually have to show that it was because of the pandemic. But again, it doesn't have to be all your income. It just has to be some income. So this is a good option if you just need a little bit more time. And we encourage, you can argue all these different things in court. You don't have to pick one of these programs. You can do this, the continuance, the CDC moratorium, and the state budget protections. They protect you all at the same time. Oh, it looks like also there's a question. Yes, the 60-day continuance will be available to people through September 28th, 2021, if the state of emergency ends at the end of this month, which it's likely to do.
Another change to Virginia landlord tenant law that happened last year that is going to continue through July 1st of 2022 is an option to enter into a payment plan. This only applies to some landlords. It only applies to those larger landlords who own 4 or more rental units. Sorry, yeah, more than 4 rental units. So it doesn't apply if you're renting from a small mom and pop landlord, but if you're in a large, multi dwelling, one of those big apartment complexes, this applies to you. So, if you fall behind on rent, whenever you receive that pay or quit notice, a landlord, for First, they have to give you that 14-day notice. It gives you 14 days to figure out what you're going to do, either get the money together or enter into a payment plan. That payment plan has to give you 6 months to pay off the balance, and those payments have to be in equal monthly installments. They can't, say, all right, you owe me $5 this month, but then, $200 the next month. That would make it difficult to pay off. There is an exception. So if you have fewer than 6 months left on your lease, they only have to give you a payment plan for whatever is the remainder on your lease. So if you only have 4 months left on the lease, they only have to give you 4 months to pay off that balance. Another important and helpful aspect of this payment plan option is that the landlord can't charge you late fees as long as you're complying with that payment plan. So they're not penalizing you for taking this option to catch up on rent. And so as long as you're continue to make timely payments in addition to your monthly rent, the landlord can't evict you. However, if you miss a payment or you miss, part of your rent, the landlord can send you a new 14-day notice. And if you don't pay everything, then they can move forward with the eviction. It can be a little confusing because this is, provision that was both in that budget protections that Victoria spoke about previously and a separate bill. So this particular one is in effect through July 1st of next year. So this will still be an option past the end of the month.
So I think it was probably obvious, but just to clarify that, if you take one of these payment plans and then miss a payment, there's nothing stopping you from then getting rent relief. With all these things, you can still get rent relief funds to pay what you owe under a payment plan. And I'm not sure we said back when we were talking about the rent relief program that they don't just pay the rent, they'll pay the balance that the landlord is alleging. So that can include court costs and late fees and things of that nature, not just their point is to get you to the place where the landlord won't evict you anymore, not just the rent. And then, someone asked, does the 14-day notice replace the standard 5-day pay or quit? Yes, until July 2022, and hopefully longer. It's in the same bill with the repayment plan. And so that'll be the amount of time that a landlord has to give you to pay in their notice up until next July. But I think it's very likely that this will be a bill in the legislature again, and Lauren can talk more about that. But hopefully it'll be extended even after July 2022.
Correct. And to dispel any other confusion, the 14-day pay or quit applies to all landlords, regardless of how many units they own. However, the payment plan provision only applies to those larger landlords. So regardless who you're renting from, as long as the Virginia Landlord Tenant Act applies to your situation and you're behind on rent, they have to give you a 14-day pay or quit notice. And there's some other new laws going to effect on July 1st of this year. So in a few short weeks, there'll be a few more changes to landlord tenant law. And the first of these is some pretty significant changes around what is called the right of redemption. This is a right that I believe Marty was somewhat involved with back in 2019. It allows a tenant to pay everything they owe, including any rent, late fees, court costs, attorney's fees, either directly to the landlord or into the court to avoid the eviction. If it was, you could either do it at the court date to prevent getting a judgment for possession entered against you. But you can also do it even after a judgment has been entered against you, but before the sheriff's eviction that Victoria talked about, and cancel the eviction. If you do it after there's already been a judgment entered against you, you have 48 hours before that scheduled sheriff's eviction to pay that entire amount and cancel the eviction and be able to stay in your home. There's some exception to where if it's a landlord who owns 4 or fewer properties, they could limit that right of redemption to once per lease term. But they can only do that if they've provided you with written notice, letting you know that's the case. They can't just suddenly decide well, you did this once already, now I'm not going to accept your money again. No, they had to have provided you written notice that you can only do this once. But for all other landlords, you can do this any number of times. They're also going to be required to provide clear language in that pay or quit notice explaining this right of redemption. It has to make clear that you have to pay everything you owe in order to redeem, and that any partial payment is not acceptable, because you don't want to have a tenant in a situation where they pay part of the rent thinking that that is going to stop the eviction and they get evicted anyways. You know, you want to be smart about how you are using the limited amount of money that you have. And you will have a right as a tenant to ask the landlord, hey, how much do I need to pay in order to, cancel the eviction? And they have to give you that exact amount. That way you and the landlord are clear on how much, rent is owed, how much is covered in late fees, what court costs are and attorney's fees, and if it's, after the sheriff has provided that eviction notice, including sheriff's fees. I know there's some concern that you would have a landlord just deflating those numbers. If you have a concern about that, then I suggest paying that into court with the clerk and trying to get some sort of hearing to make sure that that amount is valid. At that point, if you're in that situation, I strongly urge you to reach out to legal aid to help with that, because we don't want people to end up in a situation where, a landlord is lying about the amount that you owe to try to make it impossible to redeem. Now, if you do redeem, the landlord has to cancel the eviction and have that judgment mark satisfied. Having that judgment mark satisfied is really important because, if you have a judgment entered against you, that doesn't automatically mean that you're paying it. I mean, if you couldn't pay the rent previously and you couldn't redeem, it's doubtful that you're going to have that money right that second. But that landlord could take that judgment and go back to the court at a future date and garnish wages. So having something marked by the court to say that that judgment has been paid, that prevents the landlord from going and trying to garnish wages at some other point. It's also, important for things like your credit and for trying to secure future housing. It's difficult enough if you have an eviction on your record trying to find housing, but it helps if you're able to show that you've already paid off any prior judgments. Now, if you do redeem and the landlord does not cancel the eviction and the sheriff kicks you out of the property, that's called an unlawful exclusion, which I will cover in the next slide. So unlawful exclusion, which Victoria referenced at the top of the presentation, is if a landlord uses self-help measures to evict you, either by changing the locks, cutting off essential services like the water, the electricity, or doing other things to make the home unsafe for people to live there. That making the home unsafe is one of the changes that's going into effect on July 1st to make clear that that also counts as an eviction. If it's impossible for you to live there without harm, that's the same thing as, locking someone out. And if that landlord does use those self-help measures to evict you, you can sue your landlord through a tenant's petition for relief from unlawful exclusion, and you would file that in general district court. So if you end up in a situation like that, again, strongly urge you to reach out to legal aid to help you get that filed. But if it's an urgent situation, legal aid isn't picking up because it's Friday at 5 o'clock or right before the court close, I would still go ahead and try to get that filed so you can get a hearing. Go ahead and get a hearing scheduled, and then still reach out to legal aid to help you at the actual hearing. The court's supposed to hear that case or schedule that first hearing within 5 days of when you file. And then if they have that first hearing, what's called ex parte, without your landlord there, they have to have another full hearing with 10 days. Essentially, the courts are going to be required to hear these cases quickly, so you don't have tenants who have been illegally shut out, living in a hotel for weeks on end before getting before a judge. If you go to housing.bplc.org, there's a lot of information about landlord tenant law in there, including like a toolkit that kind of walks you through in a bit more detail how to file an unlawful exclusion case. But again, if you have questions or need advice, definitely reach out to a legal aid attorney. And if you're in this situation, your landlord has illegally evicted you, starting July 1st, you can recover $5,000 in addition to any cost that you incurred. So this is called statutory damages, which means regardless of what you can prove to the court, as long as the judge finds that you've been illegally evicted, you can recover that $5,000. But you can also recover any damages that has come about because of this. So if you've had to stay in a hotel, that's an expense you should be able to cover. If you've lost all of your food all those groceries you just bought and you've had to go out and buy additional food, that would be damages as long as you have those receipts. So that would be $5,000 damages or 4 months rent, whichever is greater. And that can also be a really helpful negotiation tool that if you have a landlord that's threatening to lock you out, you can point to that statute and say, hey, if you lock me out without going through this court process, then I'm going to sue you and I can get $5,000. Hopefully that'll help change the landlord's mind real quick. I see there's, oh, okay, awesome. Victoria was sharing the link. Next has to do with when the maintenance folks come into your home to do routine maintenance. So starting July 1st, landlords have to give you at least 72 hours notice before doing routine maintenance in the building. Unless you requested that maintenance yourself, then that's you inviting them to your home. But otherwise, they have to give you 72 hours notice. And that's a permanent change to the law, regardless of other situations. Another change is that during a state of emergency based on a health pandemic, so for COVID-19 or some similar state of emergency, you can provide a written notice to the landlord that you don't want that non-emergency maintenance conducted. Just if you have a concern during that health pandemic about spread of disease, provide that notice to the landlord so they're not coming in unwarranted. There are a few exceptions to that just because landlords have their own insurance policies and their own loan agreements they have to comply with of some routine maintenance. So they can come in at least once every 6 months to do that routine maintenance, but they have to give you at least 7 days written notice before they do that. It has to be at a time consented by you, so they can't just show up whenever. They have to give you plenty of time and work at a time that works for you. And whoever that person is coming in to do that maintenance has to wear PPE equipment to make sure that everyone's kept safe. But as Victoria mentioned, it seems that the current state of emergency based on COVID-19 is likely going to expire at the end of the month. So unfortunately, it'll expire before this law goes into effect, but that provision will still be there if there's some pandemic in the future that creates another state of emergency. And the last thing I wanted to go over that's going to start on July 1st has to do with the Service Member Civil Relief Act. So this is a federal law that protects, our men and women who are serving in the armed forces. Things happen, they get called away for duty with short notice, which means they'll have to break their lease. It makes it difficult to go to court to represent yourself if you get sued. And so the Service Member Civil Relief Act provides some protections for service members. Unfortunately, there's a lot of landlords in Virginia who were requiring folks to sign away their rights under the Service Member Civil Relief Act so that, they would be, have to pay liquidated damages if they broke your lease early, or, they would have default judgments entered against them if that service member couldn't show up to court. But starting July 1st, that is now illegal. Landlords can no longer include lease provisions that require tenants to waive their rights under the Service Member Civil Relief Act. So this is really important because, one of the big provisions of that is allows active duty members to a 90-day continuance of an eviction case, as well as other rights related to breaking that lease. So if you have folks who are service members, definitely let them know about this change. And if they do see that lease provision still in there, that's unenforceable in Virginia starting July 1st. All right, so I know we went over a lot of information. Feel free to ask us questions. I'm going to go ahead and stop the recording, but I'll send an email out probably sometime tomorrow morning with a copy of the recording so you can share it with others who may have missed this.